Is there a time limit to how long an attorney can question his own witness in the middle of trial? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. And the answer is no, there is no specific definable time limit about how long I can question my own witness. Now, why is that? I'll tell you why. During the course of a medical malpractice trial where you have sued your doctor claiming that number one, he was careless, number two, that his carelessness was a cause of your injury, and number three, that your injuries are significant or permanent, now the doctor turns around and says, hey, why did you sue me? I did nothing wrong. And even if I did something wrong, whatever I did didn't cause or contribute to your injuries. And then he says, hey, you know what? If I did something wrong and I caused your injuries really are not as bad as you claim them to be. And on top of that, you, the patient, caused your own injuries, or at least some of them. Those are the typical defenses. And you will find that in these medical malpractice cases, the doctor and his attorney typically will refuse to negotiate. They'll refuse to try and settle before trial. So your lawyer turns around and says, fine, we'll see you at trial. Well, that means 2 or 3 years down the road, after all this litigation, pre-trial litigation goes on, now 2 or 3 years later, you'll see him at trial. Okay, so now your case finally comes up for trial. And now your attorney has to put on all this testimony, all of the evidence, all of the proof necessary to show that you are slightly more likely right than wrong that what you are claiming is true. That number one, your doctor violated the basic standards of medical care. Number two, those violations were a cause, it doesn't have to be the cause, were a cause of your injuries. There has to be that link, that bridge, that connection. And now, number three, that your injuries are significant or permanent. And all of those things have to be confirmed by a doctor who's either treated you or reviewed all your records and confirms that. So now, at the time of trial, I call you to the witness stand. Your Honor, I call Mrs. Jones to the witness stand. Okay, and now you're up on the witness stand. The question I raise in this video is there a time limit to how long I can question you? We call this direct examination. And direct examination is different than cross-examination. Cross-examination is where the defense attorney gets up and tries to rip apart your credibility. He tries to attack you and go after you over and over again to show that what you are saying is not entirely truthful. Great, but now this is direct examination. These are questions where I want you to go ahead and give long-winded answers. I want you to take the time to explain to the jury exactly what happened in your own words. So, during the course of direct examination, how do we do that? We do that by asking open-ended questions such as who, what, where, when, how, why. Tell us more. Please explain. What did you do next? This gives you, the patient, the opportunity to go ahead and explain as much as possible. Now, you might be asking, does the jury need to know every single minute detail of every single event that occurred during the entire duration that you were treating with this doctor? And the reality is that they don't. They don't need to know all the tiny little minute details. Why? Because it has no bearing whatsoever on whether the doctor did something carelessly, whether or not that carelessness was a cause of your injury, we call that proximate cause, or whether your injuries are significant or permanent. It is important, however, for the jury to understand what happened, what you did, to describe conversations that you had that are not recorded anywhere on paper, and now to be able to explain to the jury from your viewpoint, in your own words, exactly what happened and why, and how your injuries have affected you on an ongoing daily basis. That is critically important. So, in some instances, you might be on the witness stand for only half an hour with my direct questioning. You might be on the witness stand for 2 hours if it takes you 2 hours to explain. There are some instances where you will be on the witness stand for much longer. At the beginning of the trial, the judge doesn't tell the attorneys, listen, you have only 1 hour for direct examination and only half an hour for cross-examination. No, that's not how it works. That's not how any of it works. Okay? The judge will, in some instances, give us time limits on our opening arguments as well as our closing arguments, but as far as questioning witnesses, we have no specific time limit within which to question you, our witness. So now, what about the defense when they get up to cross-examine you? Does he have a time limit? The answer is no. And even if I question you, let's say for 2 hours, now the defense gets up and says, Your Honor, I think we're going to be here for the rest of the day. The jury may be looking at their watches wondering, how could that possibly be? How could he keep her on the witness stand for 6 hours? Well, he may have lots of questions because he may want to delve into various topics that focus on credibility. And if he can show that you are being less than credible, less than truthful, then now he chips away at your credibility, which, by the way, is the most important thing in your entire lawsuit. You might think it's the facts. You might think it's the law. But no, the reality is that your credibility, your believability, the jury believing you and what you have to say is the most important fact, the most important thing in your entire case. You want to know why? Because if the jury doesn't believe you, they have the opportunity, they have the right to disregard all of your testimony. And if the jury doesn't believe you, there's a good chance you are going to lose your case. So that's why the defense lawyer is going to do everything possible to chip away at little pieces of your testimony to show that you are being less than truthful. So why do I share this quick video with you? I share it with you just to give you an insight and an understanding into what goes on in these medical malpractice cases here in New York. You know, I understand you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.